Hello, and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners, which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your training requirements. At the end of the podcast, we will explain how to get in touch if you have any comments or questions.
Hello and welcome to podcast number 133. I hope by the time this goes live you'll have had an opportunity to listen to the podcast with Brian Doyle, which is now out on the ELA website. That's elaweb.org.uk. Look under the webinars section, or have a look on Twitter and follow me there, where I posted out a link. I'm told, and I understand that what ELA are doing is making the webinar podcast available to everyone. You don't have to be a member of the Employment Laws Association to listen to the podcast, which I think is good news. Anyway, do let me know what you think of it. We're looking at doing some follow-ups for the Employment Lawyers Association, which is great. So I will look forward to maybe interviewing some other senior members of the judiciary as the time goes through. There's going to be a bit of a flurry of podcasts, actually, because in the next day or so I'm also going to record a podcast with Daniel Stillitz QC about one of his case. I think it's going to be very interesting to hear what he has to say about that. Anyway, at the moment you're just stuck with me. No guests, no presidents or anything like that. Sorry. Anyway, we have, of course, no surprises, 3 cases. We've got a case that's a follow-up on an alternative way of putting claims for damages, where it is difficult to calculate damages. The Supreme Court's offered its view on this. We have a very useful case, very illustrative, on redundancy processes, and in particular on the importance of a reasonable appeal process and bumping stop. The third case, which in fact is the one I'm going to start with, is a case that was decided earlier this week in the Supreme Court on when service of notice is effective. I think there are some lessons to be learned from this, as I hope to make clear. And, just before I start, I'm just back from Scottsdale, Arizona, where we have the Mayor Brown Partners Conference once every couple of years. I've been there a few times now. It's only on this occasion that I discovered that Scottsdale, Arizona has the Musical Instrument Museum, which claims it has the largest collection of musical instruments anywhere in the world. I spent a very happy 5 hours wandering around looking at various musical instruments. I was telling a friend of mine about my trip the other day, and he asked whether I might manage to find a favourite instrument in my wanderings. That's clearly the sort of geeky question that's going to keep me up at night. Anyway, it's a rather far-flung cultural recommendation for the Scottsdale, Arizona Musical Instruments Museum, but should you happen to be in the area, definitely worth a visit. As always, you can access the podcast via iTunes, it's on the Mayor Brown website, YouTube, and the Twitter feed, Nicholas Robertson at Nicholas ROBER11, which is also where we post out links to the cases discussed. So, on with the show. First up, Newcastle upon Tyne Hospital, NHS Trust and Hayward. This is a case which I say has split the judiciary on its way through the system. For such a decisive case, it has a very simple set of facts. Ms Hayward worked for the NHS for many years. Her contract said she was entitled to a minimum notice period of 12 weeks. She was placed at risk of redundancy. If her employment terminated by reason of redundancy on or after her 50th birthday, she'd be entitled to a non-actuarially reduced early retirement pension. Her 50th birthday was 20 July 2011. If she was dismissed, effectively, before 20th July 2011, she would not receive the early retirement. She was aware that she was facing redundancy, and at a redundancy consultation meeting on the 13th of April, she told the Trust she'd booked 2 weeks annual leave from Monday the 18th of April 2011 and was going off to Egypt and would not be back until the 3rd of May. This was all booked through the Trust's normal processes. Just so to be clear, 18th April she goes away until 3rd May. The Trust has to give 12 weeks notice that expires, in accordance with the contract, on or before 20 July. So the crucial date, 12 weeks back from 20 July 2011, is going to be 27th April 2011. And it doesn't take a genius to work out where this particular set of facts is going, now does it? So, on 20th April 2011, 7 days before the key date, the Trust, whilst she was away and knowing she was away, issued written notice to terminate her employment on the grounds of redundancy. This was emailed to her husband's email address, and it was sent by recorded delivery to her home and by ordinary first-class post. For various reasons which are not really recorded in the Supreme Court decision, the trust case in front of the Supreme Court was that the recorded delivery letter was effective to give notice of termination. Notice had to have been given before 27th April 2011, as from then afterwards, 12 weeks' notice, as I say, takes her on to or beyond her 50th birthday. So, Ms Hayward had asked her father to look after her house while she was away. He found the recorded delivery slip for the recorded letter on 21 April. On 26th April, he collects the letter and leaves it at their home on 26th April. And Mr. and Mrs Hayward arrive home on 27th April, you guessed it, the magic date, and she opens the letter and reads it late on in the morning of 27th April. So, if the point at which she read the letter was the point at which notice took effect, then she gets her actuarially non-reduced pension. If it was the 26th, 2011, or an earlier date, she wasn't. The contract itself had no rules about when service took effect. So this is all terms on the common law. When does a notice take effect to terminate a contract of employment where there are no provisions in the contract? Well, one High Court judge ruled in her favour. The Court of Appeal split 2-1, but ruled in her favour, and the Supreme Court split 3-2, but ruled in her favour. And the reason why they ruled in her favour is, I think, less important than the practical consequences for employers and employees in the future. But let's just deal with the reasoning briefly. The Supreme Court pointed out that for statutory provisions, things like unfair dismissal, the concept of the effective date of termination was construed to be the date on which the employee reads the letter or had a reasonable opportunity of reading the letter terminating employment. The cases acknowledge that if someone deliberately tried to avoid opening the letter or deliberately went away to avoid receiving the letter, there might be arguments about deemed notice. But certainly in front of the Supreme Court there was no suggestion that Ms Hayward was trying to avoid reading notice. The employer here argued notice was given when the dismissal letter was delivered to the employee's address. The employee asserted that notice had not been given until the letter had come to her attention and she had a reasonable opportunity of reading it. And, as I say, remember, we're not talking about the statutory effective date of termination here, we're just talking about common law notice. The Trust argued strongly, and I think with some reason, that common law cases generally for contracts and notice, not necessarily employment contracts, favoured their interpretation, and policy too, they said. Notice provisions would be much more certain if notice was given when it was received at the address rather than when it was read by the employee. But as I say, the Supreme Court, by a 3-2 majority, came down in favour of the employee's interpretation. Part of this was that the statutory concept of effective date of termination would then be in line with the interpretation for when notice was given for common law purposes. It's obviously beneficial to have one rule of interpretation applied to both common law contractual notice and statutory notice of termination. Secondly, the notice provisions were up to the employer. If the employer wanted greater certainty, it could put an express provision in the contract or make sure that the employee was told face-to-face at the same time as a letter was handed over, if necessary. The Supreme Court majority also took the view that the interpretation of the effective date of termination rule in unfair dismissal hasn't caused any practical problems, given the element of uncertainty that creeps in if the employee has to have read the notice of termination. So they said there was no reason to believe that it would cause a significant problem for ordinary notice of termination under a contract to support the employee's interpretation here, i.e. allowing, as I say, for a slightly less certain date of termination. So why have I spent this time talking about the case? It's obviously a pretty extreme set of facts. In the light of the fact that the Supreme Court also say that they don't think their interpretation is going to cause a problem, why do I think the case is worth talking about? The first point here is that I think this is a matter for employers to indulge in a bit of self-help. The Supreme Court are clear that it is open to the employer to specify ways in which notice is given and the time for which such notice is deemed to be received. In my terms, I think that means here the employer could have specified that notice was deemed to be received when the letter was received at the house, or when any first-class letter would ordinarily have been received. So, in this case, in my view, it's now obvious that in all but the most basic contracts there should be a deemed service provision to avoid this sort of situation arising again. Secondly, however, I think you also need to be clear to the danger of serving notice by post at all. I'm sure that in many cases it doesn't matter, but if notice is not effective until it is read by the employee, You do need to be careful about how you draft your notice of termination letters. If you have an employee with restrictive covenants in his or her contract, and you serve notice by post, specifying that the notice will expire on a particular date, a calendar date, you're running a risk. What if the employee doesn't read the letter because they're away, so that notice doesn't start running until later than you expect? But if the end point is fixed, then that is a repudiatory breach of contract, entitling the employee to resign and claim constructive dismissal. That could be catastrophic if you have restrictive covenants. In short, I think that if you do not have a deemed notice provision in your contract of employment, then you need to put one in there as soon as possible. And if you are looking at giving notice by post, you need a deemed notice provision that addresses when notice takes effect. Otherwise, it's rather more risky than you might think. Anyway, that's Newcastle upon Tyne Hospital NHS Trust and Hayward. So, next up, Garner and One Step Support Limited. This is another Supreme Court case. Typical, isn't it? You wait ages for one to come along and then two come along at once. Well, we've previously mentioned this case in podcast 107, which deals with the issue of Rutham Park damages. We got quite excited about this because the Court of Appeal awarded Rutham Park damages for breach of a restrictive covenant. And it seemed to me this could well be a very useful route to claim valuable damages in an area where it is notoriously difficult to make a claim for significant damages because of the problems of showing causation and that the defendant has caused the loss. Hopefully, here, briefly, the facts were that the individual sold the business and was bound by confidentiality, non-solicit and non-compete covenants, which she flouted. For various reasons, an injunction wasn't available, and so there was a claim for damages for breach of the restrictive covenants. Given the difficulties of showing that her breach of covenant had led directly to loss, the claim proceeded on the basis that Rutham Park damages were being claimed. This is the argument that the victim of the breach is entitled to damages equivalent to the fee that would notionally have been agreed between the parties, commercially, acting reasonably, as the price for releasing the defendants from their covenants. In essence, the Supreme Court has put an end to this judicial creativity for our purposes. They prefer to call this type of damages negotiating damages rather than Rutham Park damages, and I think that so pedants can stop saying you do realise that although it's written Rotham, it is in fact Rutham Park. Anyway, the basis of a decision is that if a claimant has a purely economic interest in the contract that is being performed, and the claimant cannot establish that an economic loss has resulted from breach of the contract, there is no loss. That gap is not to be filled by judicial creativity and negotiating damages. In this case, the commercial interest, the claimant's case, was that the defendant had broken the restrictive covenants. That was a commercial interest for the claimants. They claimed they suffered financial loss for breach. Therefore, the Supreme Court said, this should be valued in the ordinary way, and there was no discretion to award Rutham Park damages instead. It did not matter that this loss was difficult to quantify, or some parts of it were impossible to measure precisely. They did leave open the opportunity that you could have Rutham Park negotiating damages where there was a breach of confidentiality, but otherwise it looks as if it's going to be much more difficult for ordinary breach of covenants. So it was fun while it lasted, but it looks as if this route to try and claim significant damages for breach of restrictive covenants has been effectively eradicated. We've certainly been involved in cases where we were bringing damages claims for our clients based on Rutham Park, so it's good at least, I suppose, to have some clarity on the point. I think it probably means for the most part we're back to the situation where well-drafted restrictive covenants will continue to rely as their primary remedy on an injunction, whether interim or final. Damages clearly may be capable of being assessed in the light of what the Supreme Court says, but it's important that if a party is bringing a claim for damages, that this has been assessed soberly rather than in the heat of battle. So that's Garner and One Stop Support Limited. Third and final case, Dr. H. Mirab and Mentor Graphics UK Limited. This is an EAT case on an unfair dismissal claim. The respondent is a UK company, which is part of a worldwide group. The claimant started working in the UK for them in February 2013 and was Director of Sales Embedded Systems within the EMEA region. So he was part of the Embedded Systems division, whatever embedded systems are. He seems to have had some friction with a senior manager high up the managerial chain, a Mr. Perry. One of the things that underlay the claim was that in 2014 he emailed his immediate manager saying that the effect of a restructure that was being proposed back in 2014 was to demote him, and he was not prepared to accept a demotion. Bear that in mind. In 2015, the respondent recruits a German employee based on Germany, reporting into the claimant. His name was Mr. Braun. During 2015, however, the respondent comes to view that there's insufficient business opportunity in the region in the claimant's area of business, and on that basis it decided that his position, the sales director position held by the claimant, was no longer required and should be eliminated. The claimant was placed at risk in February 2016 and was told about the review of the business strategy. On that basis, it was felt likely there would be no requirement for the Director of Sales, since it was a unique role. He was told he was at risk of redundancy, subject to consultation. He felt he was being unfairly singled out as a result of the friction with Mr. Perry. However, redundancy consultation proceeded and the claimant was given a link to an internal website showing vacancies worldwide. The respondent decided to proceed with the redundancy and notified him of that fact. The claimant had a right of appeal, which he exercised. His appeal was rejected after a telephone hearing, which appears to have been fairly cursory. One of the things the claimant asserted was that he should have been compared with the account managers in other areas outside the UK. But this was rejected by the company on the grounds he was sales director rather than an account manager, and the respondent took the view that it was only required to consider positions, pools in the UK. The Employment Tribunal upheld the company's case that the claimant was redundant and didn't accept that Mr. Perry had exercised an inappropriate influence. The Employment Tribunal did not agree that the employer was right to limit consideration of redundancy pools to positions in the UK. It pointed out the claimant was part of a global structure and he would have been entitled to being compared with any other directors of sales in the embedded systems division, including those working in other countries. However, there were no other directors of sales in the embedded sales division in this company, and as such, it was a unique role. The tribunal said there was no evidence that the claimant had ever offered to take up an account management position, which is the one down from him, and that there were no vacancies at that level in any event. In the Employment Tribunal's view, it would have been possible to have considered whether to have bumped one of the account managers, but the claimant himself didn't suggest it, and there was no duty on the employer to consider it unless the claimant suggested it. Pausing there, this turned out to be mistaken as a matter of fact because the claimant had said something, and indeed the respondent had acknowledged he had said something along those lines of possibly dismissing an account manager. I'll come back to that. In relation to the appeal that was held by telephone, the Employment Tribunal accepted it was a, quote, superficial exercise, unquote, and carried out without, quote, independent judgment, unquote. However, because they felt the original hearing was fair, it did not matter that the appeal was a superficial one. The EAT, however, disagreed with a number of the Employment Tribunal findings. In particular, the EAT accepted that the claimant had himself possibly suggested bumping Mr. Braun to make way for him. Firstly, the EAT was clear the employee had the right to a fair appeal. Whilst a fair appeal process could in theory cure an unfair initial hearing, the opposite also applied. In other words, an unfair appeal could damage an originally fair process, although of course, if no real injustice was caused, this might be something that reduced the level of damages. Secondly, it was incorrect, the EAT said, to suggest that the employee had to have raised the issue of bumping before the employer was under any duty to consider it. Here, the facts were quite unclear, given the employee had previously objected to being moved down to account manager. Equally, he had made a reference to dismissing Mr. Braun instead of him, but that might have been a reference to bumping, or it might have been the claimant suggesting that if they dismissed Mr. Braun instead of the claimant, they could leave him as Director of Sales. So this has gone back to the Employment Tribunal to consider this, and the EAT was careful to say the respondent might reasonably have objected to the idea of bumping having considered it, or might not have understood that was what the claimant was saying. So I think there are three important points coming out of this case. First, the Employment Tribunal found the employer had an obligation to consider, in the pool of redundancy equivalents, individuals in other countries. Although this didn't form part of the appeal, because the Employment Tribunal found there was only one Director of Sales globally, I think it's an important point. We've seen a number of occasions where employers have declined to include equivalent employees working abroad. And let's be honest, there may be good reasons for this, but there do need to be reasons. Secondly, the issue of bumping is one that comes up a reasonable amount. Most employees in our experience tend to take the view that it is their job, and if that job has been made redundant, they should accept they are being made redundant rather than throwing one of their colleagues under the bus to try and save themselves. However, employers need to have considered the issue of bumping because I'm certain that employee advisors will take it up if it is not addressed in the consultation. Employers might well take the view that there is a settled team, or that there are individuals who are stronger performance at the more junior level. They might take the view that an individual who is effectively stepping down to take a more junior role on a more junior salary than the previous one is unlikely to stay for any length of time in the role. And this would then mean that one of the more junior employees has effectively been wrongfully deprived of his or her job. But these points need to be considered as part of the redundancy exercise. Finally, I think the comments about the appeal process are very important. The appeal was superficial and without independent judgment. There's a temptation, we know, for an appeal process conducted by a senior manager to be a rubber stamping exercise with no independent consideration. But this case in the EAT makes it clear that just by itself, that sort of process could lead to an entire dismissal being ruled to be unfair. Even if at the end of the day the employer is able to convince the tribunal that no injustice was done overall, it's going to have an impact on damages, but that's assuming that a tribunal still thinks that you are the good guys in all of this, and if you've failed to conduct a fair and appropriate appeal process without good reason. No assumption. You couldn't make that assumption. So that is the case of Mirab and Mentor Graphics UK Limited, as I say. So finally, it just remains for me to say thank you very much indeed. Do look out for the ELA Web podcast. Also look out for the podcast with Dan Stillitz QC, and I look forward to speaking to you again in 2 weeks' time after I get back from Argentina and Brazil, where I am celebrating my 30th wedding anniversary. I know, seems impossible for one so young, doesn't it? Thanks very much indeed. Bye.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments, please email Nick on nrobertson@mayorbrown.com. Our podcasts are an overview of cases. How the law applies in any particular case will obviously depend on the individual circumstances, so please take legal advice if any of the matters discussed are relevant to issues that you are dealing with. And thank you for listening.